want to thank Planned Parenthood, the American College of Obstetricians and Gynecologists, members of the legislature, and all the partner organizations and stakeholders with us today, and thank you. When we learned about the then draft Supreme Court opinion to overturn Roe v. Wade, I know many across our state and nation were scared and worried about their own health and the health and safety of their family members and their friends and their neighbors. We all were. And of course, Friday came and our worst fears came true. In one fell swoop, the Supreme Court overturned Roe and ruled that the U.S. Constitution confers no right to an abortion, effectively stripping Wisconsinites and many Americans across the country, our family members, friends, and our neighbors, of the ability to make their own reproductive health care decisions without interference from politicians. Half the people in our state now have fewer rights than they did 4 days ago, fewer rights than their mothers and their grandfathers or grandmothers had before them. And that is an unconscionable legacy. For those who died because they were not entitled to these rights, for those who fought hard to gain and protect those rights, and perhaps most importantly for the kids who might not grow up without those rights altogether. And the weight of the Supreme Court decision hits close to home for us in the Badger State. Wisconsin is among the handful of states that still has an archaic criminal abortion ban on the books that originated in 1849. It's been on the books before the Civil War and decades before women even had the right to vote, and bans nearly all abortions, even those in cases of rape and incest. In January, I stood with Democratic legislators and Attorney General Josh Kaul at our state capitol and called on the Republicans to do the right thing. Take proactive action before the Supreme Court decision and repeal that ban. And when the Republicans packed up and concluded their regular session work without taking action and ignoring the majority of Wisconsinites who support safe, legal access to abortion, I again stood with these folks in this room, called the legislature in the special session to repeal this archaic law once and for all, and last week, even knowing a Supreme Court decision was imminent, they had another opportunity to do the right thing, and again, Republicans refused. Yes, the people of Wisconsin were abandoned by the Supreme Court, but they've also been abandoned repeatedly and willfully. They were failed by our Republican legislators who sat around and watched this happen in slow motion and didn't do a damn thing to do it, to take care of it. They failed to listen to the will of the people and do their jobs. They failed to even debate or discuss what this decision would mean to the health and safety of the people they serve. And they failed to protect freedom and the right of every single Wisconsinite to make the reproductive health care decision that's right for them. And on Friday, my family and the families of Wisconsinites across the state felt the failure of that event. Wisconsinites now face the alarming reality of the consequences of Republican inaction and the dangerous effects that it will have on folks and families across our state. Well, I've always promised I'd defend access to reproductive health care. And I've promised to veto legislation that would restrict reproductive rights, and I've kept those promises. So as I said last week, I'd fight this every way we can with every power that we have. And that's what we're going to do. Today I'm announcing that we're taking this fight back to the courts. I've authorized Attorney General Josh Kaul to file a lawsuit today that is a direct challenge of Wisconsin's 1849 criminal abortion ban. An overwhelming majority of Wisconsinites supported Roe and making sure abortions remain safe and legal in Wisconsin. And if Republicans won't do their part, what's right, and help the people of the state, then we will. I'll hand things over to Attorney General Josh Kaul in just a minute, who will speak more to this what this lawsuit means. But our message to Wisconsinites is this: we will never stop fighting to make sure that every single Wisconsinite has the right to consult their family, their faith, and their doctor to make the reproductive health care decision that's right for them. Decisions that should be made without interference from politicians or members of the Supreme Court who who don't know anything about their life circumstances, their values, and their responsibilities, period. So whether it's this lawsuit offering clemency to doctors convicted under this archaic law, or not appointing prosecutors who would enforce it, we are together in this fight, and we will not back down. So thanks again to all the advocates here today, and healthcare providers and reproductive healthcare leaders. Thank you for your endless dedication and persistence. We're with you. Now I'd like to turn things over to Attorney General Josh Kaul. Josh.
First, thank you, Governor Evers, for your continued leadership as we fight to protect and now restore reproductive freedom in Wisconsin. Since last Friday, we have begun to see the impacts of the U.S. Supreme Court's decision overturning Roe versus Wade. Safe and legal abortion has stopped in the state of Wisconsin. My office has begun receiving questions from sexual assault nurse examiners who are wondering whether they can still dispense emergency contraception, who are asking whether there's an exception under the 19th century abortion ban for cases of rape and incest. And the reality is that if that 19th century abortion ban remains in effect, sexual assault victims in Wisconsin will be required under Wisconsin law to carry their rapist's baby to term without getting medical intervention. That is not a free society. Women in Wisconsin deserve better. The Supreme Court decision has made Wisconsin's women less safe, less equal, and less free. And we need to change that. Now, Governor Evers and I have taken decisive action in the last few days to minimize the harm from the Supreme Court's decision. Governor Evers has made clear that he will grant clemency in cases in which people are prosecuted under the old ban. My office has been clear that we will not use our resources to investigate or prosecute anybody under Wisconsin's 19th century ban. But minimizing the harm isn't enough. We need to do much, much more. So today we have filed a lawsuit that asks the courts to clarify that Wisconsin's 19th century abortion ban is not in effect. We are making two legal arguments in support of this case. Number one, there are a series of laws that were passed subsequent to Roe that provide regulation for lawful abortions in Wisconsin. Those statutes are directly inconsistent with Wisconsin's 19th century abortion ban. It can't be both legal and illegal to provide an abortion to protect the health of a mother. We've also argued that Wisconsin's abortion ban has fallen into disuse and can no longer be enforced under Wisconsin law. There's a legal doctrine known as desuetude that we argue applies here. Wisconsin's criminal abortion ban has been unenforceable for more than 50 years. Wisconsin actually had a decision that predates Roe, decided in 1970, that invalidated Wisconsin's abortion ban. So for over 50 years, abortion rights have been protected in Wisconsin. But even before those decisions, although there were abortion bans in most states around the country, people knew then what we continue to know, which is that making abortion illegal doesn't stop abortion. It stops safe and legal abortion. In fact, when those bans were in place, abortion was commonplace, but the laws were very rarely enforced, and they were disparately enforced. So we have contended that those laws, because of the history of limited enforcement and the fact that they haven't been enforced for more than 50 years, no longer can be in effect in Wisconsin. I want to add, too, that there has been discussion from the Supreme Court about returning this issue to the states. But what we're talking about, if this 19th century ban is enforced, is not returning this issue to the states. We're talking about returning Wisconsin to the 19th century. This law was passed well before women had the right to vote. It was passed before the Civil War. It uses terminology that is outdated and leaves doctors and others uncertain as to what exactly the law provides for. And that law cannot fairly be said after 50 years of being invalid to represent the will of the people of the state of Wisconsin. If legislators think there should be an abortion ban in Wisconsin, they should go into session and pass that legislation. I'm confident the governor will veto it, but legislators, if they want this law enforced, need to stand by it. A bill that was enacted before any of them was born, before anybody here was born. So today we are bringing suit. We are seeking to have the 1800s ban declared unenforceable, and we are also going to continue to fight for legislation. We were here not too long ago when Governor Evers called the special session. It was held 1 week ago today. And I want to point out that last week Senator Kapenga emphasized that the Supreme Court opinion hadn't been issued yet. That was last week Tuesday. Well, now the Supreme Court opinion has been issued. And we still need the legislature to act, because while this litigation is playing out, regardless of what ultimately happens, access to safe and legal abortion has stopped in Wisconsin. Women in Wisconsin are already beginning to feel the effects of that legislation. So we need our legislators now to step up and act and to restore reproductive freedom for women in the state of Wisconsin. So with that, I'm going to turn it over to Dr. Kathy King, the medical director at Planned Parenthood of Wisconsin.
Good afternoon, everyone. As Attorney General Kaul said, I am an OBGYN and medical director of Planned Parenthood of Wisconsin. Thank you to Governor Evers and Attorney General Kaul for taking this important action to challenge Wisconsin's 173-year-old abortion ban in court. On behalf of the patients and communities Planned Parenthood of Wisconsin serves, I and my staff are incredibly grateful for and supportive of your leadership on this litigation. I have provided full spectrum reproductive health care, including abortion, in Wisconsin for the past 25 years. The patients of reproductive age that I and my staff serve had never known a time when safe, legal abortion was not available in our state. Our patients already face all kinds of injustices and inequities. They are dealing with poverty, lack of resources, distress while struggling to parent the children they already have, abuse, and health risks, all that manifests into their decision to terminate their pregnancy. Last Friday, after the SCOTUS decision overturning Roe, we were forced to deny people care and turn them away due to the threat of felony criminal prosecution from a vague, ill-defined law from 1849. Suddenly, without the federal protection of Roe, in an instant, we who care so deeply about being there for our patients, no matter what, could not be there for them at one of the most pivotal times in their life. Against everything we value, we were forced to cause suffering. But suddenly, in an instant, we shifted to do everything we could to help people access care across state lines, but no, not everyone will have the privilege to access that care. When I think of people being forced to continue a pregnancy they do not want, giving birth when they do not want to, facing the health risks of continuing a medically complex pregnancy against their will, I know it will magnify the pain, distress, injustice, and inequity that already burdens their lives. As a physician committed to the health and safety of my patients, I know the fall of Roe will exacerbate the maternal health crisis in this country. When compared to similarly wealthy countries, the United States ranks last with the highest maternal mortality rates. In Wisconsin, you are 5 times more likely to die from a pregnancy-related cause if you are Black versus if you are white. A study published in the Journal of Demography in October 2021 1 month after the Texas SB 8 abortion ban found that banning abortion nationwide would increase U.S. maternal mortality by 21% overall and 33% if you are Black. 1 in 4 women during their lifetime make the deeply personal decision to have an abortion. For most people not involved in this work, these are nameless, faceless statistics. Abortion stigma leads to silence, which leads to more stigma. It is now more important than ever to break this cycle and normalize abortion for what it is, health care. Please remember, people who have abortions are your friends, family, neighbors, co-workers, church members. They are people we know and care about. I and the majority of Americans and Wisconsinites believe that people should have the basic human right to decide whether to have a child or not. I hope we can all agree that the person who is pregnant should be the one to make the deeply personal, moral, and ethical decision based on their life circumstances, whether to continue or terminate their pregnancy. Not an elected official with a political agenda, not a person trying to impose their personal religious beliefs on someone else, and not an archaic law written at a time when Black people were enslaved without any rights to bodily autonomy and women could not vote or hold elected office. On behalf of my medical colleagues and the people we serve, I again thank Governor Evers and Attorney General Kaul for your leadership and for moving forward with this important litigation. The lives and health of Wisconsinites depends on it. Thank you. And with that, I will turn the mic over to Dr. Kristen Lyerly.
Thank you, Dr. King. You moved us all. My name is Dr. Kristen Lyerly. I'm a board-certified obstetrician-gynecologist from Greenbay. I take care of women and people across the spectrum of their lives, from puberty to menopause. I manage high-risk pregnancies. I diagnose cancers, and I help people solve problems that are so personal that they often live with them for years before they summon up the courage to have them treated. I am also an abortion care provider. At least I was until last week, when the Supreme Court repealed Roe, and in an instant, took away our fundamental rights to our own bodies, decisions that impact every aspect of our lives for the rest of our lives. I am here today as a woman and a mom, and most urgently, a physician, to elevate the voices of the people I serve. The moms who can't afford to have another baby. The college students who have staked their futures on their educations. The parents who are making heartbreaking decisions about a desperately desired but highly complicated pregnancy. I'm here on behalf of my patients, my colleagues, and all of us who have made it possible for women to obtain safe, legal abortion here in Wisconsin until last Friday. When we lost Roe, an antiquated law from 1849, you've already heard about it today, that's 1 year after Wisconsin became a state and over 70 years before women earned the right to vote in this country. An 1849 law criminalized abortion without exceptions for rape or incest. In fact, the only exception the law allows is for the life of the mother, and we need to have 3 physicians sign off in order for this exception to be valid. So go with me on this. Imagine this scenario. You're in Eagle River, Wisconsin. Do you know where it is? It's beautiful, way up north. A woman is brought to the emergency department at 2 a.m. on a Sunday morning. She's diagnosed with an ectopic pregnancy, a pregnancy outside of the uterus. This is the #1 cause of death in women in early pregnancy. It's a common condition, but tell me, where in Eagle River are you going to find 2 other qualified physicians to evaluate this patient at this time in this city? And tell me, how sick is sick enough? Abortion is common. 1 in 4 women in this country will have an abortion in their lifetime. Making abortion illegal will not stop abortion, but it will cause women and families and communities to suffer, and some will die. Abortion is health care. My colleagues and I, many of whom are standing behind me today, we study for years. Actually, we never stop learning because we are constantly striving to better understand the complexities of taking care of pregnant people. This isn't simple stuff because every patient is unique. We have dedicated our lives to taking care of our patients, which for many of us includes helping people get pregnant, taking care of them throughout their pregnancies, and delivering them when the time comes. Our culture revels in the joy of pregnancy, and we should. But we also have to keep in mind that every pregnancy is not joyful. Women commonly suffer from chronic health conditions that make pregnancy dangerous and even sometimes fatal. Pregnancy complications, including previable premature rupture of membranes, genetic and developmental problems, and ectopic pregnancy, to name a few, these complications frequently threaten desired pregnancies, forcing women to make agonizing decisions when all they wanted was a healthy baby. When we walk beside our patients and their families during these challenging times, we provide support and care and guidance. We participate in the healing process, emotionally, mentally, and physically. This is a relationship built on trust. But that trust is destroyed when politicians interfere with our sacred patient-physician relationship. Politicians who can't explain what makes an ectopic pregnancy dangerous or why a diagnosis of anencephaly is devastating. Management of conditions like these and so many others is complicated, and it's steeped in deeply personal decisions that can only be made by pregnant people. There is and never will be room for politics or politicians in my exam room. Attorney General Kaul, thank you on behalf of my patients, colleagues, and neighbors, those of us who believe in community and taking care of each other, like Wisconsinites do, for your support and action as we look to the future, together, and as our state motto proclaims, forward. And with that, I'd like to hand it back over to Governor Evers.
Well, this is a time where we're moving forward. We feel positive that we're taking a very, very, very important step to return the rights to women in the state of Wisconsin. They shouldn't be second-class citizens. So I feel confident that we're doing the right thing, and we're going to win this one. So with that, Attorney General Kaul and myself will be glad to answer any questions you might have.
Question for the Attorney General. Could you talk us through some logistics of filing this? When will it be heard? Who will hear it? Which court it goes to? And maybe the political makeup of that court.
Yeah, the suit was filed very recently, earlier today, in Dane County Circuit Court. It will get assigned to a judge in Circuit Court. Then the case will move forward. The issues that are raised here are primarily legal issues. Some court cases, there's a lot of fact development that goes into them, but here it's a question of whether the statute remains in force. And so it's my hope that this case will make its way through the court system fairly quickly so that we can get some clarity for Wisconsinites. Of course, there are often appeals that happen after that, but that's where it will start.
Attorney General, if a judge agrees with you and says that this is not enforceable, in your view, does that make abortion fully legal in the state?
Yeah, well, our argument is that abortion is legal in Wisconsin right now, but ultimately a court is going to resolve that question because, as I said before, the legislature has left us in this position, the Republican-led legislature, where we have conflicting sets of statutes. So usually the legal rule is that the statute that was passed more recently is the one that controls, and so our argument is that that has, by implication, invalidated this old ban, but ultimately a court will decide that if a court does declare that the old ban is not enforceable, then it will be clear that access to safe and legal abortion has been restored in Wisconsin.
Can you give any lay details of the 1970 case? Some doesn't quite go back that far. Almost.
Yeah, it was a case just slightly prior to Roe, and it was a similar argument. The argument was that the abortion ban that Wisconsin had in place violated fundamental rights, and the case is called Babbitts, Babbitz, and the court ruled that Wisconsin's ban was in fact unconstitutional.
Governor Evers, are all the eggs in this basket at this time? If not, what conversations are being had behind the scenes for travel or resources, financial or otherwise, to Illinois, Minnesota, others?
Yeah, certainly those discussions happened before the Supreme Court made their ruling, and of course the folks in Illinois and Minnesota are being helpful. We're hoping to have services available nearest to our borders as possible. But at the end of the day, that is not going to help all sorts of vulnerable women who can't cross our borders because they don't have the wherewithal to do that. And so this effort on behalf of the Lieutenant or the Attorney General and myself and all the women standing behind us and men standing behind us is a real important one. We're going to continue to look at other avenues. We're going to continue to make sure that it is that reproductive health services are available to women across the border, but that is an unacceptable status quo.
Do you expect this lawsuit to be successful under the current makeup of the Supreme Court?
Well, first, I think we're right on the law. These statutes are in conflict, and we will see what ultimately the courts decide. Certainly, we have a 4-3 majority, a conservative majority in the court, but we've also won some very important cases before this court. And like I said, when the law's on your side, as it is in this case, I like our chances.
Yeah, and time is of the essence. I mean, every day that we delay, waiting for a different Supreme Court or waiting for something else, that's a day that women in Wisconsin do not have access to reproductive health.
Going right off of that, the doctor kind of presented scenarios of what is currently the landscape for some patients seeking abortions. Is there some guidance now for those who find themselves between now and whenever the next legal action is announced, so that they may stay within the legal bounds? What's kind of that message?
So one of the reasons we want to bring this suit is because we need clarity. The legislature has really abandoned the people of Wisconsin in a time when we need them to step up. We have unclear laws. Because it's been unconstitutional for more than 50 years, they've certainly never been applied in a modern context. So Wisconsinites need clarity about how these rules apply, and the truth of the matter is the legislature has left us without that and with conflicting laws in place. So we're going to do as much as we can to provide clarity, but we've been left in a difficult spot. It's why it's so important that Republican legislators come to session to protect reproductive freedom. The Democratic legislators behind us here are ready to act. What is standing between us and restoring reproductive freedom is the failure of the Republican legislators to step up.
Governor Anna?
You asked for a temporary injunction on the 1849 law as this forces its way through. As you mentioned, there's been a lot of back and forth.
Today we filed the complaint. We will develop the litigation strategy as we keep going, but as of today, what's happened is that there's been a complaint filed. I do think this case will likely move pretty quickly and we'll get a full resolution before too long because it is really a question of law.
Governor, anecdotally, anecdotally, in your conversations with colleagues across the aisle over the past couple of months, do you get a sense they appreciate how deeply personal this decision is to the people who make the decision? Obviously, the emotion is evident here. But what about for opponents of abortion? Is it strictly letter of the law, this is what we, or they have an appreciation for the family impact?
I see very little of the latter and a whole bunch of the former.
Yeah, and could I just jump in on that too? One of the things about this law that I think gets lost is that this ban on abortions is deeply anti-family. A lot of the women who obtain abortions are mothers. They're often in very difficult circumstances, including potentially ectopic pregnancies that could leave kids who are alive without a parent. It is so important that we empower women and their families to make these decisions and not politicians, for that reason among so many others.
Yeah. It's about following the science, and our colleagues on the other side of the aisle have some difficulty with that concept.
Last question, Mary.
So you're not asking for an injunction?
Today, in today's filing, we have filed the complaint, which initiates the legal process. It's my expectation that we will ask for a definitive ruling before too long in the case. We will continue, assessing our legal strategy and what steps we take as we move forward. But as of today, we've just filed the complaint.